Okay, good morning, everyone. Today is Wednesday, January 15th, 2025. It is 10:04 a.m. and this proceeding is hereby called to order. This is a public hearing and proper notice has been provided. We are convening in person and on Zoom. This hearing is being audio and video recorded, so parties are asked to please speak loudly and clearly into the microphones provided at the podium and the witness table. Attorneys are asked to please stand when presenting evidence. And this is an adjudicatory hearing in the matter of Matthew Hubbard. The commission is represented by attorney Timothy D. Hartnett, and the respondent is represented by attorney Kevin B. Coyle. My name is Elizabeth Smith, and I'm the hearings administrator for the Peace Officer Standards and Training Commission. The Honorable Charles J. Hely will serve as the presiding officer of this hearing. Provided for the parties are exhibit notebooks with Bates numbers in the table of contents on the first page. So I do ask when referencing the exhibits during the hearing, please use the Bates numbers located at the bottom center of each page.
All right. I'd like to ask counsel for the parties to just stand for a moment, introduce yourself, introduce your client. You may stand, sir, when you have a chance. Go right ahead, Mr. Hartnett.
Timothy Hartnett on behalf of the Division of Police Standards.
All right, then, Mr. Coyle.
Good morning, Your Honor. Kevin Coyle on behalf of the respondent, who is Matthew Hubbard, who's here with me.
All right, welcome. Thanks for coming in. Please be seated. The procedure will be, as suggested by our hearing administrator, the parties have the right to call and examine witnesses, to introduce exhibits, cross-examine witnesses, submit evidence, make objections, bring motions, and present arguments. I want to add that we are grateful for your cooperation with each other and being candid in a number of things you've stipulated to, and it's not required, but it does help one another understand the process and focus on the important issues that you could see them. The commission will present its case first. The commission may, if desired, make a brief opening statement. The respondent may follow with an opening statement or may wait until the end of the respondent's case, wait until the end of the commission's case. Each witness will be sworn immediately before testifying. Cross-examination will occur as soon as the witness testimony has been presented by the party calling the witness. Please reference exhibits using the redacted exhibit binder provided to you. When referencing a specific page, look for the Bates number located at the bottom of the page. That's the most easy reference we have. To the extent that the parties have agreed on an exhibit as a joint exhibit, please let us know. And when initially referring to the exhibit. The rules of evidence do not exactly or by the letter apply, but they're certainly good guidance for us to consider if you have a concern that any offered evidence should not be accepted. Evidence in general, according to our regulations, will be admitted if it is relevant, not privileged, and the kind of evidence which reasonable persons are accustomed to rely on in conduct of serious affairs. It is not necessary to take exceptions. In fact, I don't, even my many years back, remember any time being required to take exceptions. You object, judge can make a ruling, that's good enough. But this is being extra careful in particular. All right, before we proceed, is there any preliminary matters you would like to discuss?
Your Honor, I have two exhibits which I've provided to counsel.
Okay,
and
good.
I understand there's no objection to them, which I'd like to offer.
Great, Mr. Coyle, you can step forward and give them to our hearing administrator.
I've seen
Ms.
them.
Smith.
I've seen them and I have no
That's
objection.
great. Thank you very much.
One is a medical record, which was omitted from the original package.
Okay,
The others are some letters of reference on behalf of. the
excellent. We'll
respondent.
get to them then.
Thank you so much.
All right, so our administrator will mark them in appropriate
Yes.
way. Thanks, Mr. Coyle. It's good timing on putting that forward. Other than that, everybody ready for Mr. Hartnett's commission's statement?
Just for the record too, All the exhibits that are in the binders, these are joint exhibits. My understanding that these are all in evidence. If not, I can move to have them in evidence, but
Very well, and I understand that's agreed, correct?
Yeah, I do not object to the admissibility of these documents. I may argue the significance somewhat differently.
Sure, of course.
than, counsel.
Thank you very much.
Good morning, Your Honor. At the end of this hearing, two things will be clear. One, the respondent was convicted of a misdemeanor larceny, and that the victim of that larceny was his former employer, the state of Connecticut. The second thing that will be clear is that he falsified a document in order to obtain his recertification. Now, most of the key facts in this case have been stipulated to, and the remainder can be found and are supported by the agreed upon exhibits in this case. Let me start by providing some background. On August 7th, 2020, the respondent was injured. He injured his ankle while working as a correctional officer for the Department of Corrections in the state of Connecticut. As a result of his injury, he needed surgery and various medical treatments and was placed on long-term medical leave. From August 7th, 2020 through July 5th, 2022, he requested and received temporary total disability payments from the state of Connecticut's workers' compensation insurer. At the time of his injury, the respondent was also employed as a part-time special police officer for the Agawam Police Department here in Massachusetts. On July 1st, 2021, the respondent, along with every other individual who was employed as a police officer at that time, was automatically certified by an act of the Massachusetts legislature. However, all officers then had to apply for recertification by a set date based on their last name. Since the respondent's last name fell within A through H, he needed to apply for recertification on or before July 1st of 2022. Under the commission's regulations, specifically 555 CMR 7.06 subsection 3, one of the requirements for recertification was that officers attend a basic training program. However, there were many special officers and reserve officers, like the respondent, who were working as police officers but had never attended a basic training program or a police academy. So there was this temporary program called the Bridge Academy. There was a temporary basic training program run by the MPTC, which allowed officers to bridge the gap between whatever they had learned before and a full academy training. Now, these new certification and training requirements created an issue for the respondent, because at the same time he needed to get recertified, he was still claiming to be totally disabled because of his 2020 ankle injury. And this is where the respondent's misconduct occurred. By his own admission, the respondent drove to and actively participated in Bridge Academy and Agawam Police Department in-service trainings, while at the same time wearing a walking boot to his appointments for the workers' compensation doctor and collecting temporary total disability benefits from the state of Connecticut. And as stipulated in evidence in the court records found in the exhibits, the state of Connecticut conducted a workers' compensation fraud investigation. And on September 19th, 2022, the Connecticut's investigator signed an affidavit stating that he had found that starting in May of 2021, the respondent's claim of total temporary disability was fraudulent because he was able to and was observed performing physical tasks, including, among other things, driving to and attending the various police trainings. As a result of those findings, the respondent was charged in the state of Connecticut with workers' compensation fraud, which is a felony. On April 26th of 2024, as part of a plea agreement, the respondent pled guilty to 3 reduced charges of larceny in the 4th degree, which is a misdemeanor in Connecticut. As part of his plea agreement, he received a 1-year suspended sentence and 2 years of probation for each larceny count. As a result of his misdemeanor conviction, the commission now has the authority to suspend or revoke his certification. Now, while decertification for a misdemeanor is discretionary, and in many cases it may not be necessary or appropriate, it is certainly appropriate in this case, because as the And the respondent will testify and he'll try to explain and maybe even try to justify his actions. But at the end of the day, he was convicted of stealing from the government, larceny of the victim, who was the state of Connecticut. That is a crime that should permanently bar anyone from any job in public service, let alone law enforcement. But stealing from the government was not the respondent's only misconduct. The evidence will show that he falsified a document in order to obtain his recertification. Misconduct that is, for which decertification is mandatory under Massachusetts General Laws, Chapter 6E, Section 10A4. Specifically, he lied on a form that's called the Initial Hire Medical Standards Medical Examination Form. And just for the ease of everyone, I will just refer to that as the Initial Hire Form from here on out. And as the parties have stipulated, this Initial Hire Form was submitted so that the respondent could get the medical clearance he needed to attend the Bridge Academy. And by his own admission, the respondent knowingly provided false information about his medical history on that form. For example, he falsely answered no when he was asked whether or not he had any history of injury or abnormality of his arms or legs. He also said no when he was asked whether or not he had any occupational injuries. Two things that are clearly false because he was literally receiving benefits for an ankle injury at that time. So it's pretty straightforward. He lied on the form and his motives are obvious. He was trying to assure that he could get the medical clearance he needed to attend the Bridge Academy, and he needed to attend that Bridge Academy in order to get his recertification. Or to put it a more simple way, he falsified a document in order to obtain his recertification. For all these reasons, at the end of the hearing, the division will ask that you find, first, that the respondent was convicted of 3 counts of misdemeanor larceny, and that larceny was especially troubling given that the larceny was from a public entity. And second, that he falsified the document in order to obtain recertification. And the division will ask that based on these findings, you recommend that the commission revoke the respondent's certification to serve as a law enforcement officer in the Commonwealth of Massachusetts. Thank you.
Okay, thank you, Mr. Hartnett. Mr. Coyle?
Yes, Your Honor. Matthew Hubbard, the respondent here, is a 56-year-old man who had a career as a correctional officer with the Department of Corrections in the state of Connecticut. He started that career over 20 years ago. He suffered an injury while on the job as a correctional officer, interacting with an inmate, which ended up resulting in surgery to his Achilles tendon. And that kept him out of work for a considerable period of time. And it was during this period of time when this Bridge Academy issue and the whole certification issue arose in Massachusetts, where he had for many years been a part-time officer in the Agawam Police Department. He will testify that as a part-time police officer, he had averaged somewhere in the $20,000 range of salary or payment for his services as a part-time officer, mostly working various details and whatnot around the town, as well as taking regular shifts. The injury he suffered obviously prevented him from doing that. It certainly prevented him from having any direct contact with inmates where the risk of injury is obvious. So he was recovering during the relevant period of time that we're here. It was during this period of time that the post commission and the post legislation became enacted in Massachusetts, and the standards for part-time officers involved training, which was made reference to by Attorney Hartnett for this Bridge Academy. He was at that time on leave from his position as a correctional officer, and his position with the Department of Corrections was as a correctional officer. So he had direct contact with inmates basically all the time he was working. And there isn't any question that until he ultimately reached a full recovery from this, that he was inappropriate. He couldn't work in the presence of inmates because of the risk of further injury. So he was out at that time. He was unable to perform all of the essential duties of a position of a correctional officer, but he wasn't completely crippled. He was not under any legal obligation to refrain from anything other than presumably activity that would prevent him from impair his recovery or would place him at some greater risk of further injury so that he would not be able to go back to work when his injury was healed. He was unaware that there was an investigation. He did not believe that he was doing anything that was contrary to these obligations as a recipient of workers' compensation. He was going to all of his appointments. He was progressing. And he didn't think that he was doing anything that was inconsistent with a full recovery or impairing or delaying his recovery so he could return to work with the Department of Corrections. He was never told that there was any restriction on him doing this type of activity. His doctor verified that while he couldn't be a correctional officer, he could take the training that was involved in this Bridge Academy. So when the issue of the Bridge Academy came up, he filled out the various paperwork, and there isn't any question, he's not denying, and continues to regret, that he did not answer all of those questions accurately. They were wrong answers. He should have put down that he had suffered an injury to his leg, that he was receiving compensation, and there were, of the 60 or so questions that are on this form, he should not have just simply said no to all of them. There were 3 or 4 of them that he clearly should have said yes to. His motive for doing this, it was not deemed essential for him to have this training at that moment to retain his certification through the Bridge Academy, but he was very determined. He wanted to take the Bridge Academy as it was being offered at that time. He was home doing essentially nothing. His doctor said that he could take that training, and he, in a misguided way, thought that it wouldn't affect anything, answered these questions improperly. If he had actually, answered the questions properly, there probably would have been some sort of follow-up that may have caused him to be unable to attend this particular opportunity to take the Bridge Academy. I don't believe it would have ever disqualified him for taking it because he has completely recovered. In fact, when all of the criminal matter and everything was completed in the state of Connecticut, he could have gone back to work. They would have taken him back to work. He chose at that time to retire on a superannuation retirement because he was eligible for that. The criminal charges in Connecticut were terminated with an agreement with the state's attorney's office down there that he would plead guilty pursuant to the doctrine of Alford, or North Carolina v. Alford, which is a plea of guilty without admitting the facts upon which the criminal complaint was issued. The choice that he had to make at that time was, even though he felt and his attorney felt that I did not represent him in the Connecticut proceeding, were defendable, and he well could have gotten a not guilty on those charges, he would have forfeited his pension if he had been found guilty, so that he could not, under any circumstances, allow that to happen at his age, at his position in life. The rest of his financial future was really dependent on him having access to that pension. And that was the big reason that he entered a guilty plea, was careful to enter it under the provisions of North Carolina v. Alford. And that's how that case was ended. If he had been more thoughtful, and if he had answered the questions that are at issue here, and which clearly are untruthful, he would have been he would not have been disqualified. He could have gotten the training in some other Bridge Academy opportunity, and we wouldn't be here today. But he did, and we're here. The issue that we think is very relevant here is, and this I'll explain or go into more, I assume we'll be submitting written briefs in this case, a line of cases which says that for statutes which are punitive in nature, they should be construed strictly against the punitive outcome. And this is kind of a subtle or nuanced issue, but we will argue that this wasn't necessary for him to get certification. This was a timing issue more than it was the actual issue of the bridge training. If he had simply taken his chances and waited for the next opportunity to take this bridge training, nothing about those answers, if he had answered them correctly, disqualified him from being recertified. It was just a matter of whether he could start his Bridge Academy at this point in time. So I will argue that this was not a falsification for the purpose of recertification, because he could have been recertified even if he had done it the right way. Again, as far as the misdemeanor charges in Connecticut, they were made under the Alfred, North Carolina v. Alfred doctrine, and we hope that you will understand that somebody at his age and his point of his career had to make that decision in order to protect his financial security in the future. That would be what I would have.
Okay. Mr. Coyle, thank you very much. Just checking out my notes here a little bit. Very well. So how do you recommend we proceed? Is there a witness to be heard by either side?
Not on my side, Your Honor. I was going to rest on the papers. I would rest on the papers
Thank you very
and
much.
the exhibits and the stipulations.
So we can discuss them a little bit later, and you have no witness to call.
Correct.
All right, then, Mr. Coyle.
I called Matthew Hubbard.
Very well.
So you wanted to sit at the witness chair?
Yes. Judge Julie, did you want me to swear this in or did you want to?
Usually, I'm used to clerk's doing it, so go ahead.
Sure.
Okay.
Mr. Hubbard, do you solemnly and sincerely affirm under the penalties of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Please identify yourself.
Matthew Hubbard.
You are the respondent in this post proceeding, is that fair to say?
Yes, sir.
And how old are you?
56 right now.
And where did you grow up, Mr. Hubbard?
Born in Springfield, Massachusetts, moved to Feeding Hills at about 12, 13 years old. Lived there the rest of my life.
Feeding Hills being a district of the town of Agawam.
Yes, sir.
And can you briefly tell the court your educational background?
Up to high school,
And where did you attend high school?
Agawam High.
And at some point in time, did you become a correctional officer in the state of Connecticut?
I did,
And when was that?
2003.
And what assignments or duties did you have as a correctional officer during your time as a correctional officer?
I pretty much did it all. I was kind of a go-to guy. They kind of looked to me to handle certain tasks. And I stepped up whenever they needed me.
Fair to say you were in the jail. You were interacting every day with inmates.
Oh, yes.
And did you have any other assignments in there? Were you ever assigned to any department or anything that?
You say almost every post within the prison, up to and including live parole hearings, which they asked me to man.
Okay. Now, at some point in time, did you have an incident in which you injured yourself?
Yes.
And can you briefly describe that?
Responding to a code of 2 inmates fighting, and ended up tearing my Achilles, a partial tear, which the doctor said was worse than a complete tear, but ultimately needed surgery to rectify that issue.
Remember when that was?
The date of the injury, I believe, was August 7th of 2020.
2020. And you were unable to work as a result of that injury. Is that fair to say?
As a correctional officer, correct.
And so what was your course of treatment in response to that injury?
Initially, workers' comp insisted that even though the doctor said physical therapy will not repair a torn tendon, they made me try physical therapy first. So painstakingly, we did several months of physical therapy before obviously still resulted in the need for surgery.
Okay, do you remember when the surgery was?
Sometime in January of the following year.
2021?
Yes, sir.
And can you again briefly describe the whole medical process, you know, physical therapy or whatever followed that?
Surgery, went into a hard cast. Doctor said I'm going to be in a hard cast for 6 to 8 weeks post-surgery. Pretty much restricted, to the house. And then at some point, he cleared me to begin physical therapy, which was twice a week.
And did that progress to some lesser device than the hard cast?
Came out of the hard cast, started physical therapy, and went into an air cast, or a boot, they called it,
And how long did you wear that boot?
for quite some time,
And did you have to wear that boot at all times?
pretty much all times.
Was there some period of time where it was less and less necessary?
Yes, the objective was to wean me off of needing to wear that boot, because although it would protect my Achilles and it made it feel better, it would also, if worn for too long of a duration, could weaken the supportive muscles.
And can you give us the time frame when you're wearing this boot and weaning yourself off of it?
I don't remember exact dates, but like I said, it was several months that I was wearing this boot, quite some time that I was wearing the boot.
Now, at some point in time, you became aware of the changes in the requirements for these part-time police officers. Is that correct?
Yes, sir.
How long had you been a part-time police officer in the town of Agawam?
I believe at that time, about 24, 25 years.
And what would you say your earnings, generally, your annual earnings were, let's say, for the 5-year period before you suffered your injury?
I'd say somewhere between 25 and 35,000.
And fair to say that once you suffered this injury, you could no longer perform those duties.
Correct.
And at some point in time, you became aware that the post legislation required that you as a part-time officer take some additional training beyond what you had previously received.
Yes, sir.
And at some point, was that what is typically called a bridge academy?
Yes, sir.
And what's involved in the bridge academy?
It was firearms training, defensive tactics, and EVAC, which is emergency vehicle training.
And how long did that training take?
It was 40 hours for firearms, 40 hours 1 week for defensive tactics, and 40 hours for EVAC.
So
Could you
total.
pause one? Let me just slow it down and make a few notes here. Okay, I have a firearms training, 40 hours, defensive training.
Defensive tactics, 40 hours 1 week.
Tactics, okay. And what was the third thing?
Firearms, defensive tactics, and EVAC were each 40 hours 1 week of training.
Yeah, I don't know what that last one is.
EVOC, emergency vehicle training,
Okay.
cruiser training.
Emergency vehicle training.
Yes, sir.
Okay, thank you very much.
Yes, Your Honor.
And what was involved in, let's say, the firearms training?
Again, just shooting at various targets. There was no running or jumping or anything of that nature. You're just mostly static training that you're shooting at targets.
And the defensive tactics?
Same thing. That was in the discussion I have with my doctor is it's in a controlled environment. There were no inmates, only other police officers. No real risk of re-injury.
And the defensive or vehicle training, what was involved in that?
For all of these trainings, I was picked up at home by an officer and driven to and from. So I never drove to or from these trainings. Only the emergency vehicle training, the courses were about 3.5 minutes long. And at that point, my doctor had suggested that for very short periods of time, I drive to start getting that, used to that motion again. Moving my right foot.
Let me ask you this, before you took this training, did you consult with your doctor as to whether or not it was appropriate for you to be able to do all of the physical requirements of this training?
Yes, sir.
And in fact, did he give you a document indicating his approval?
He wrote a doctor's note approving me to do the said training.
And you did complete this training, is it fair to say?
Yes, sir.
Now, did you believe that you were violating any restriction that had been placed on you as a result of you being on workers' compensation in Connecticut?
I did not. I felt I was physically capable at that point of performing this training.
Were you ever, when did you become aware that you would become the subject of an investigation of your activities?
I don't recall exactly who contacted me or when. Unfortunately, I don't recall. Of course, this August will be 5 years. So the timeline is kind of, tough to recall exact dates and times and who.
Well, let me ask you this. Were you ever interviewed by the people doing this investigation?
No, sir.
Nobody ever contacted you to find out if you had any explanation for what you were doing?
No, sir.
Ultimately, you were terminated by the Agawam Police Department. Is that fair to say?
Yes, sir.
Were you ever, well, strike that. Was the first knowledge that you had been investigated when you became aware of criminal charges?
I believe I was contacted and told that I was going to have to turn myself in at a police station.
Okay, and where was that? Where did you turn?
If I recall correctly, that was Rocky Hill Police Department.
And were you arrested at that point?
Booked, yep,
So that was the first time you knew that there was any investigation going on?
correct.
Nobody ever contacted you to get your side of the story and why you did what you did?
No, sir.
Now, when this Bridge Academy issue came up, where were you in your recovery from this injury in terms of, what your boot was and what limitations your doctor had told you were imposed on you to have basically make sure you recover as fast as possible?
I was going to physical therapy twice a week. I was wearing the boot as needed. Of course, he recommended, utilizing the transportation provided and wearing the boot because, of course, my Achilles would become aggravated from an hour of physical therapy. So to utilize the transportation provided by workers' comp, wear the boot as needed. But I was going to physical therapy twice a week.
Were you also driving to run your own errands, to go to the grocery store and things like that?
Short distances, he had approved me to the bank or the grocery store. He said, again, keep it local, short distance, to start getting used to that motion.
And was the physical therapy you had to go to more distant?
Yes, that was in Enfield, Connecticut.
And did that physical therapy itself make it difficult for you to drive?
Oh, yes, it definitely aggravated the Achilles.
Now, eventually your criminal complaints against you were resolved by a plea agreement. You're aware of that, of course.
Yes, sir.
And you discussed this with your attorney?
Yes,
And did you understand that you were pleading guilty under the terms of North Carolina v. Alford?
I wasn't 100% clear on the guilty, but he explained it to me that I wasn't agreeing with everything that I was accused of. But it was the Alford Act, and he suggested that be the way that I go.
Did the outcome of those criminal charges have any impact on your eligibility for your pension?
No, sir.
Well, let me go back. Could those charges, the original charges, have affected your eligibility for a pension?
Yes, sir.
And in what way?
The felony charges could have cost me my pension,
Would they have disqualified you from the pension?
and I certainly couldn't have gone back to work with felony charges.
When did you actually or fully resolve from the whole injury situation?
When did I return to work?
Yeah,
That was July 5th. And I'm trying to remember the year, but I would think 22 or
Two would
3,
that be?
I believe so.
So you went back and was that some sort of a less than full duty assignment?
The state of Connecticut, or at least our facility, had done away with light duty posts, but they had what's called a recuperative post, where I do still have some inmate contact. And can be drafted and mandated to work 16-hour shifts, but was sent back on a recuperative post.
And were you put on suspension by the Department of Corrections once the criminal charges were filed?
Yes, sir.
Now, after the plea was made, what was your status at work?
I'm out on suspension from the state of Connecticut, from Department of
Correct.
Correction.
But what would did they ever move to terminate your employment?
They did their own investigation and they actually said they were okay.
Objection. Move to strike that.
Are we talking now about Agawam or Connecticut State?
I believe you're asking about.
I was asking about Connecticut Department
Okay,
of Corrections.
and you object because?
Because I've never seen any documentation of this and never heard of this, nor is there any evidence to support it. It's just his hearsay. And I
Well-
don't believe that's real, although we accept some hearsay, I don't believe coming from respondent himself, that makes it reliable.
Okay, well, I don't know about whether it's covered by documents, but I will make the session.
What was your status with them after this criminal matter in Connecticut? And I'm talking about Department of Corrections. What were your options when that was over with?
I was told with misdemeanors, I could either take my retirement at that time because I had 20.5 years, or I could return to work.
And what did you choose?
I chose to retire.
And why was that?
I just felt it was the best option at that time. I had done 20.5 years, had already been injured, and it was just best to take my pension and secure that and move forward.
I have nothing else.
Okay, Mr. Coyle, thank you very much. Mr. Hartnett.
Thank you.
Hartnett, excuse me.
Pardon, yep. Morning, Mr. Hubbard.
Good morning.
Good to see you again.
Good to see you.
You were recertified by the commission in 2022, correct?
Yes, sir.
And prior to receiving that recertification, you had to complete the Bridge Academy, right?
Yes, sir.
And before you could get, and you talked about the courses you took, the EVOC, and just where everybody understands, defensive tactics, that's making arrests, physically handcuffing people and responding to violent people, correct?
Not perpetrators in this training, other police officers.
Okay, but the officers acting as perpetrators, right? The purpose of it is for you to learn how to handle, how to effect an arrest and how to defend yourself on the street,
Right.
correct? So that's a physical activity, right? You acknowledge that.
Nobody's trying to hurt each other. It's just other police officers. At 25 years, I knew how to handcuff somebody.
It's a physical training, correct?
I guess you could call it that.
And driving a car, that's physical training, right?
Driving the cruiser at EVOC, yes.
Sure. And this isn't just regular driving around the town. This is defensive training. This is driving a cruiser in a particular way to be safe and to go after criminals, correct?
3.5-minute courses.
Is that a yes?
Yes,
Thank you. And before you could take any of these courses, you needed to get a medical clearance, correct?
yes.
And getting that medical clearance involved, meeting with getting a physical by a physician, correct?
Yes,
Okay, and in this case, that was Dr. Gary Bombardier.
I believe that was the name.
Okay. And before you met with Dr. Bombardier, you were required to complete what's known as the initial hire medical standards medical examination form. You remember that?
Yes,
Okay. And if I call it the initial hire form, you understand what I'm talking about?
yes.
Okay. And a copy of that form, it's Exhibit F in the minor. You have it in front of you. You can take a look at it. It actually asks that you take a look at it.
Yes, sir, I see it.
Okay, and on the very first page of this document, which is Bates numbered Hubbard redacted 130. See that? On the very first page, there's a signature here. That's your signature, correct?
Yes,
And that's dated January 8th, 2022.
yes,
And we go to the next page. I'll just take a step back for a second. You can keep it open, but just to clarify, so in August of 2022, you were injured, your Achilles, while working as a correctional officer for the state of Connecticut, correct?
yes, sir.
And you needed surgery as a result, correct?
Yes, sir.
Okay. And on January 8th, 2022, the day that you completed this form or the day you signed it, you were still receiving temporary total disability benefits from the state of Connecticut for your injury to your ankle or Achilles.
Yes, sir.
Now, if you could turn to page 2, if you're not already there, and this is page number Hubbard redacted 131. Take a look at that and the next page. And I go through a few things here. So under here, it says section A, it says medical history. You see that?
Yes,
This completed by the examinee before the examination. Correct?
yes,
You're the examinee, right?
yes,
And it asks here, first off, it says, please answer questions accurately and completely. You see that? Okay. And
Can we slow down a little bit?
oh, sure, absolutely.
What's the page you're on now?
Sorry, it's Hubbard redacted 131. It's the second page of that document.
Okay. So we're now on 132, correct?
No, we're still in 131.
Okay, I'll stay there for the moment.
Right at the top where it says under instructions is what I'm talking
Let
about.
me, let me.
If you want to take a chance to take a
Yeah,
look at
take a
it.
pause on this.
Sure.
Okay, Mr. Hartnett, I've gone as far as the instructions, 6 or 7 lines.
Okay, and then it says here, have you ever had any of the following and asked you to check this one? You see that?
yes,
Okay, and on number 15, it says injury or abnormality of arms and legs, and you checked no, correct?
yes,
And that was false, correct?
yes, sir. I had a previous injury.
And number 66 says occupational work injuries, you checked no, and that was false, correct?
Correct.
And 66, okay, let me
66,
make a note of that,
yep.
thank you.
And then number 67 says 67 says disability or compensation claim, and you checked no. And that was false, correct?
Yes, sir.
And number 71 says medical treatment in the past 12 months. You checked no, and that was false, correct?
Yes, sir.
Go to the next.
I'm going to ask you to repeat the number you were just.
Sure,
referring
it
to.
was 71.
71, okay, that's
Sure.
very bottom right.
Yep.
Okay, thank you. Go
And then we're
ahead.
going to go to the next page. It's number 72.
Okay.
It says here, CAT scan, MRI, or other special tests. You marked no, and that was false, correct?
Yes, sir.
Because you had to get a CAT scan or an MRI. as part of-
MRI.
MRI as part of your treatment. And if we could just go back, sorry, to the first page of that document. The part where you signed. And there's a paragraph. It says consent and certification completed by the candidate. You see that? It's on the first page.
First page.
I'm not sure where you are.
It's the very first page of this
Same
doc-
document?
Yep,
Okay,
sorry.
Thank you very much.
Sorry, I think he means the first page of Exhibit F.
Yes. Which is Hubbard redacted 130.
Okay,
I'm on page 131, but where is
So
this?
go page before that,
I'm sorry,
page before that,
page before that.
okay?
Okay,
At the bottom, there's a paragraph, it's titled Consent and Certification. You see that?
yes,
It says completed by the candidate,
yes, sir,
correct? And you're the candidate,
yes, sir.
correct? Okay, and you, in fact, this is where you signed. I want you to just go to the second sentence here. In the body of the paragraph. And it says, I certify that all the information given by me in connection with the examination will be correct and complete to the best of my knowledge and belief. Did I read that correctly?
Yes, sir,
And you signed that document, correct?
sir.
Thank you. In fact, it wasn't all correct. You in fact had lied, proceeded to lie 5 different times on the next 2 pages, correct?
I regretfully checked boxes I should not have.
And the reason you didn't check those boxes, the reason you provided false information here is because you knew that if that information about your pre-existing medical issues, that it might hurt your ability to get medically cleared, correct?
I wanted to seize the opportunity of this for the Bridge Academy presented to me at a time when I had all this downtime on my hands and wasn't really capable of going back to work in a hazardous duty environment, but talking with the doctor felt that this in-service training, not a new cadet academy, I was physically capable of that.
And if you check the boxes that told Dr. Bombardier that you had these pre-existing conditions, that might make that more difficult, correct?
Possibly, I didn't think so. I think I felt ultimately I would be clear that I was going to be physically capable of returning to work in the prison. So I was certainly physically capable of completing this in-service training.
Do you remember being interviewed by the division earlier last year, being interviewed by us, by me?
Yeah, yes,
And there was a compliance agent by the name of Anthony Matarese, who's not here today.
yes, I recall.
Okay, your attorney was present for that.
Yes.
And do you recall that during that time, when we asked you why you provided false information on that form, you said that you were just trying to get through the training and that you thought it would hurt me as far as trying to retrain my certification? Do you remember that?
I don't recall, but if that's what's there, then
I'm going to ask that we play a clip, just a very brief clip.
okay. Could you give me that again? The numbers you just gave me?
Oh, the numbers in the form?
Yeah, the question you just asked, where would I find it?
Oh, the quote, it's going to be an exhibit M. I'm going to play it. I was
Okay.
quoting something that I'm going to play the whole clip now.
Oh, okay.
It's exhibit M, and I'll give Ms. Smith the timestamps. It's started 41 minutes and 30 seconds. And,
Is this exhibits L and M are audio and video recordings?
Yes, we'll have them this one.
Okay, so
so
I don't have paper on this, but I can learn from looking at the screen, correct?
correct.
Okay, I'm happy to go.
Yeah, and I'm going to ask that Ms. Smith play 41:30 through approximately 43:55. Give her take a few seconds. It's fine.
Are you having issues?
Yeah.
Okay. Give us one moment. or-
Sure, absolutely.
And what was the timestamp again?
41:30. The start.
I'm making notes.
Sorry, go ahead. Back to the timeline here.
So back in January 5th of 2022, you were cleared by Dr. Gary Bombardier of the Holyoke Medical Center to attend the Bridge Academy. Did you list any information about your injury, about an MRI, about your disability claim, about your medical treatment in the past 12 months on the initial higher medication exam form?
I don't recall, but I don't believe so.
Why not?
Well, I've had surgery on my right shoulder. I've had hernia surgery. I kind of felt like, you know, maybe this would hurt me as far as trying to retain my certification. And that if I could get through this in-service training, it's not a new cadet academy. I'm not running or jumping or doing push-ups. I'm just trying to get through this in-service training. That's all I was trying to do, sir, is after 25, 26 years invested, maintain my certification.
You can stop it there.
Let me ask you to pause and make a few notes.
Absolutely.
Okay. Okay, thank you.
Switch gears here a little bit. On April 26th of 2024, you pled guilty to 3 counts of larceny, correct?
Misdemeanors, yes.
And the misdemeanor was larceny.
It's the
correct?
Alfred Act, yes.
Yeah, and larceny is stealing, essentially.
I couldn't quite hear you.
Sorry, larceny is stealing.
Oh, I got you. Okay, thank you.
And for this, for that, you received a suspended jail sentence and 2 years of probation, correct?
Yes,
And I believe that was for each count, correct?
yes, sir.
Okay. And the victim of that larceny ultimately is the state of Connecticut, correct?
Yes, sir.
Because they're the ones who ultimately pay the insurer who was paying your benefits, correct?
Yes,
So in essence, you were convicted of stealing from the government, correct?
yes.
And just, you talked about the Alfred plea, and I just want to ask you something about that. You took that voluntarily, correct? No one coerced you or to do
Yes.
that, correct?
Correct.
You made a calculus, there was a risk, correct?
Yes,
You made a decision, you didn't want to risk losing your pension, so you decided voluntarily to take that plea, correct?
correct. The only reason I took it.
Okay. And there was the risk was that you would be found guilty because the state of Connecticut might prove that you actually committed those crimes, correct?
Even if there was a 1% possibility. Yep, couldn't risk it.
But that's why you made a calculus based on your own risk assessment, and you made a decision, a voluntary decision.
Along with my attorney, yes.
Okay. And there are consequences. We're all adults. There are consequences for our decisions, correct?
Yes,
Okay. And you recognize that one of the consequences of being convicted is that you are now considered, or for taking a guilty plea, even an Alfred plea, you at least recognize now, the consequence of that is that you are now considered convicted for purposes of your law enforcement certification, correct?
yes.
Did you get any authorization from the Department of Corrections before attending the, your Bridge Academy or Agawam training?
From the Department of Correction, no, at that point, there was no communication with them.
In fact, you didn't tell anybody over there that you were doing that, right?
No, there was no communication with them.
Okay. You mentioned a doctor's note. Copy of that doctor's note is Exhibit K. Can you take a look at it?
Thank you.
Just to be clear that the time your appointment, Dr. Bombardier was in 2022, January of 2022, and you attended the Bridge Academy shortly thereafter in early 2022, correct?
Yes, sir.
Okay, and this doctor's note is dated January 6th, 2023, correct?
We had discussed the Bridge Academy prior to this note. When it became an issue, we discussed it again, and he said, yeah, I'm considering this supplemental to your physical therapy. If you need a note for it, beyond our discussion about it, I'll provide a note for it.
He didn't provide you any documentation. You have no documentation that that doctor cleared you before you attended the Bridge Academy, correct?
Prior to this note, no, I don't believe
No,
so.
this is a note written a year later after the fact that says he would have cleared you.
Correct.
Essentially. Okay. But the only one who cleared you was Dr. Bombardier, right?
And this doctor.
Well, no, he didn't though, right? Because there's only one who did it in writing. Let's put it that way. Is Dr. Bombardier, correct?
No, this is in writing from my surgeon
At the time before you took the Bridge Academy.
Yes.
The only one who cleared you in advance
in advance, yes,
was Dr. Bombardier, right?
yes.
And Dr. Bombardier was the one you met with and the one who you provided false information to before you met with him, correct?
Yes.
Thank you. No further questions.
Okay, thank you. Anything else, Mr. Coyle?
Quickly on redirect, just so I understand and make it clear. You had discussed the demands of the Bridge Academy prior to going to the Bridge Academy with Dr. Schutte, isn't that correct?
Yes, sir.
And he had told you that it was okay.
Yes, sir.
And after it,
I'm sorry, I object, Your Honor. Just for the record, I understand they've objected similarly, but for
Well,
the record, I'd like to object and move to strike that
Hold
answer.
on,
'cause-
hold on. To the extent that in redirect, you're giving leading questions, I'd ask you to more open-ended questions.
No, I agree with that. That's my concern is that we're talking about, he's representing what the doctor said. That is, and I understand that there's hearsay but I just want to object to the record that while hearsay is generally admissible, there is a standard that it need to be something that is reliable, and I don't believe that information that comes directly from the respondent who has an obvious interest, that should be considered on the same level. I don't believe it's reliable for him to represent what the doctor said or cleared him. If he wanted the doctor to come and do that, he could have had written documentation from him, or he could have done something to that effect. Generally allowing everything, but that is a bridge too far.
All right, do you want to say something, Mr. Coyle?
well, there was no requirement for him to have prior authorization from his doctor. He talked it over with him, and then after it all hit the fan, he asked the doctor to.
What I'm going to do is permit your questions and answer. We'll see what the answers are. How much weight they get, we'll see.
Did you, prior to going to the Bridge Academy, did you discuss the possibility or your hope to be able to take that bridge training and the nature of the training you'd receive?
Yes, sir.
And did he tell you that it was appropriate and that there was nothing wrong medically with you taking that training prior to taking the training?
Yes, sir.
Now, let me just make a note again. I didn't get that doctor's name.
Shooting,
How do you spell that? for me?
It's right here.
TSCHUDY.
And Attorney Coyle, just for the record, were you trying to introduce the letter from Dr. Schutte as an exhibit?
Yes, I thought that, yeah, those
Yes,
would be,
and do you mind if that's Respondent Exhibit A?
that would, either that or if you want to just, there's no objection. So if you want to just follow along and make it N and O.
That's fine.
Sure, so the letter from Dr. Schutte will be Exhibit N.
And the attaboy letters would be O.
Yes.
Thank you. I have nothing else.
I'm going to make a few notes so we can all just follow while I do that. Okay, what was O? That's N.
Yep, this is O. These are the-
Okay, so O is Sacred Heart Church.
Yeah, there's a bunch of letters.
Non-senior, okay. Oh, it's a package of letters.
Yes.
Okay. All right, so you're finished your questions. Mr. Coyle, did you want to add anything else?
I just have one question. Since we brought up these letters, I just want to clarify something. Do you have a copy of those letters in front of you?
of the
The,
character reference letters.
Oh,
Yeah.
no, but I can
we can,
make a copy.
I don't mind if he was, you can even have mine. Um, this first letter, it does reference post, correct?
I'm sorry.
The first letter references post, correct? The first letter references this commission, correct?
Yes,
Okay, none of the other letters reference the post commission, correct?
I'm unsure. I'd have to look at all of them. But
Can you look at, if you just go ahead and look through that packet, aside from the first, just go ahead and take a minute and take a look through the whole packet. I want to ask you something. I want you to take a look, particularly at the date on all the documents that.
okay.
Aside from the first document, which references posts, so I'll accept that it's sometime more recent. The rest of those ones are, or the majority of them are dated 2022, correct?
Summer 2022, summer 2023, some are not dated at all. That was
Okay.
because these were for the original criminal trial in Connecticut.
Okay.
That's why they're dated back then.
I just wanted to clarify that. Thank you.
Okay, thanks, Mr. Hartnett. All set?
I have nothing else.
Very well. Thank you, sir. Your testimony's over.
Thank you, Your Honor.
Okay, you can resume the table.
We'll be back to you.
Sure.
Okay, any other witnesses?
I'm not trying to.
No, you're on.
Any exhibits that you want to call to my attention or proceed to a closing or do it in a closing if you're ready? Am I missing anything that needs to come before the closings?
Your Honor, I would prefer to submit a brief.
That's fine. That is fine. So you don't feel you want to make an oral statement now, it's okay, but if you do, that's okay too. But you definitely can submit a brief. In fact, our regulations say that. I think that's specified in the regulations. All right, so the answer is yes. How about you, Mr. Hartnett? Do you want to make any oral statement or summary?
If Attorney Coyle's not going to rely on just a brief, I'll rely on just a brief as well.
Okay,
Make it
good.
easier.
Now, so that leaves us this way, if I'm not mistaken. We have the joint pretrial memorandum, the one most recent, January 8th. And there's a lot of details, a lot of stipulations, which are clear, very clear what they are. So I welcome, there was a brief or a memorandum in support of each side. How much time you recommend? I'll be away next week, so I'm not going to be working on this next week. I'm visiting family, but I'm open to reasonable suggestions for when you should submit brief or a memo.
Sure, I'm not unique in this. I got a lot going on. I would request if we use a 30-day time frame and then extend it to the Monday following, that would bring us to February 18th.
Okay, let me say this.
I'm sorry, Your Honor.
What do you want to say?
I'll just add to the extent it affects how you might want to respond. I actually have another hearing before this commission in 2 weeks, so I wouldn't, although I would typically say a shorter day is fine, I wouldn't mind a length 30 days as well.
Okay,
in this
now,
case.
just for my future planning, is the hearing you have coming up one of assigned to me?
I believe it is.
Yes.
Okay, good. Yeah, I thought so. It starts with an H too, is that right?
Yes,
Heller or something along those lines?
correct.
Okay, so let me jot down the date you suggested. I'll accept it.
That would be February 18th, Your Honor.
Okay.
Is that a holiday? Your Honor?
No, it's the day after the holiday. The holiday is the 17th.
Oh, okay, so it's Tuesday, the 18th.
Yeah.
Okay, got it.
Okay, counsel, thank you very much. If you have nothing further to suggest or highlight, I appreciate all your good work and we'll take it step by step.
Thank you.
Your prediction that we would be done in an hour turned out to be just about on the money.
Well, you gentlemen are real professionals. I welcome that. You get to the point and you do not neglect your respective positions at all. So hang on to this.
Yeah, you can take these. And Judge Hely, just for the record, the hearing is adjourned.
Thank you very much.